Good morning, and welcome to today's session, where we'll be discussing protecting and enforcing your intellectual property overseas, a meeting with the USPTO's IP Attachés. Today, we'll meet with several of the in-country attachés, as well as the Director of Texas Regional United States Patent and Trademark Office, and Dominic Keating, the Director of the IP Attaché Program at the USPTO. Joining us today are Hope Shimabuku, Director of the Texas Regional USPTO Office. As the Regional Director of the USPTO Texas Regional Office, Ms. Shimabuku carries out the strategic direction of the Undersecretary of Commerce for Intellectual Property and Director of the USPTO. She is responsible for leading the Texas Regional Office, focusing on the region and actively engaging with the community. Ms. Shimabuku ensures the USPTO's initiatives and programs are tailored to the region's unique ecosystem of industries and stakeholders. Also joining us today is Dominic Keating, the Program Director for the IP Attaché Program from the Office of Policy and International Affairs. Mr. Keating is the Director of the Intellectual Property Attaché Program at the USPTO. He provides legal and policy direction to U.S. intellectual property attachés based in Brazil, Russia, India, China, Switzerland, Thailand, Kuwait, and Mexico.
Thank you so much for that fantastic introduction. It's been a little while since our office has visited the Wond'ry. We actually were out there pre-pandemic, and we have engaged on a number of occasions on some of the different events that you have worked on. And so it is great to see y'all again and to be a part of today and to be a part of this wonderful cadre of individuals that you have on the phone. I think that Dominic will be introducing the IP Attaché program and other things as well. But the Texas Regional Office is located out of Dallas, Texas. And one of the missions that we have is really to be able to engage in outreach with stakeholders like yourself at the Wond'ry and at Vanderbilt. And so we are constantly connecting with you, and we really appreciate all the time and the information that you have given us, as well as giving us the opportunity to be able to share the resources that we have with you. And so with that, I'm going to hand it over to Dominic to talk a little bit about the IP Attaché program and introduce the great group of people that are here online as well.
Thank you, Hope and Yessi. We really also appreciate the opportunity to be here today. And we think it's a really an amazing opportunity to speak with startups and students and professors about the Attaché program and what it does. And the Attaché program helps to improve intellectual property systems internationally. And the attachés themselves spend a lot of time helping startups, small businesses, and medium-sized businesses, as well as other stakeholders to navigate foreign intellectual property systems. They often respond to requests for assistance by stakeholders, and they provide information to these stakeholders that can help them to address challenges they're facing overseas. And there are times when they advocate directly on behalf of the U.S. stakeholder, especially in times when the U.S. stakeholder is being discriminated against in a foreign IP system. So how do the attachés do their work? Really, it's three main ways. One is where they directly advocate by sitting down with host government officials and explaining U.S. positions on intellectual property and how local IP systems can be improved and why that would be advantageous to local officials and the people overseas. Another way that they advocate is by training government officials on intellectual property matters, and this could be judges, training judges and prosecutors and police officers, customs officials, and many others to help them become better at what they do on intellectual property and also to understand our perspectives. And a third way that they advocate is by conducting public awareness programs so the public in the countries where they're based can understand intellectual property and why it's important, why it should be protected, and why it should be respected and enforced. So that's a longer term approach that bears fruit over a period of years when more and more people start to support the protection and enforcement of intellectual property, and also those views filter up into the policy making mechanisms in the country. So we've heard a lot of success stories, stories about attachés who've conducted a training program for police or customs officials, and then we've seen, immediately afterwards a raid, seizing large quantities of counterfeit tennis shoes, or a customs officer seizing a consignment of counterfeit goods. We've seen laws and policies changed, having a huge impact on the ability of stakeholders around the world to protect and enforce their intellectual property rights in these foreign jurisdictions. So we've seen a lot of great progress, and I think a lot of that is due to the talent of the attachés. And you'll hear, I'll tell you a few words. I'll say a few words about the attachés who are here with us today. But the bottom line is they're really experienced people. They're seasoned IP professionals, and we're really fortunate to have them as part of the team. So the first one is Conrad Wong. He's dialed in because he's at the U.S. consulate in Guangzhou, and he is not allowed to do any video conferencing from there. He has been based in Guangzhou for a number of years, and this is in fact his second assignment in Guangzhou. He spent 5 years on a previous assignment there as intellectual property attaché. But before that, he worked in policy issues at USPTO headquarters, at one time as a trademark examining attorney, and he's even worked for a trade association on counterfeiting and other intellectual property issues. So our next speaker will be Luciano Marchione, who's our intellectual property specialist, or local intellectual property attorney, who works for us in Brussels. Luciano is a former professor of law, of intellectual property law. He has a master's degree in addition to his Juris Doctor degree in law, which is a rare thing to have. And he's an expert in all matters in dealing with European intellectual property law, but especially on copyright and trademark issues. We have David Kellis, who's with us. He is based in Rio de Janeiro. David is one of our more recent additions to the team, but he's added a lot of value already. He speaks, and a number of our attachés speak foreign languages. David speaks fluent Portuguese. David comes to us from a law firm in Colorado where he was a shareholder, and he is immersing himself in meetings with foreign government officials and already accomplishing a lot. The next speaker we'll have today is John Kabeka. John is based in New Delhi, India. He has had a long and distinguished career with USPTO. He was previously our West Coast Regional Director. He, before that, at one stage, he was a group director in patents for USPTO. He has done an assignment to the U.S. Trade Representative's Office. He's played many senior and important roles with the agency. And then we have Pete Maraveri, who is based in Abu Dhabi. Pete was formerly assigned to Kuwait City, so this is essentially his second assignment as well. And Pete covers the entire Middle East and North Africa. And Pete was formerly a patent attorney and a trademark attorney in Georgia before he came to USPTO. He worked as a patent examiner for USPTO and then moved up into the policy shop before he became attaché. So we have a really, once again, a really accomplished group of attachés with us today, and a broader accomplished group of attachés in the program. We have 13 IP attachés scattered around the world. Each of them have local IP attorneys and other local staff reporting to them. And they also have a team of specialized attorneys in USPTO headquarters that support them. And that team includes patent attorneys, trademark attorneys, copyright attorneys, and enforcement attorneys. So we have just a lot of resources. And I'm really excited about our conversation today. So maybe we can start by turning the floor over to Conrad.
Okay, Dom, thank you so much. And thank you all. Good morning to all of you in the United States. Good afternoon to my colleagues in Europe, and also good evening to my fellow colleagues that are in Asia. My name is Conrad Wong. I am the IP officer here at the United States Consulate General in Guangzhou, China. This is one of 4 consulates. Our main embassy is in Beijing. We have 3 of us actually, or 3 offices, I should say, here in China. My colleague Duncan Wilson is the IP counselor at the embassy in Beijing. I have another colleague who's inbound, Ms. Julie Schwartz. She's going to be at the consulate in Shanghai. I'm down here in southern China, Guangzhou, is the provincial capital of Guangdong Province. We are just over the border, about 85 miles from Hong Kong. So I cover a lot of the southern and southeastern part of China. So that would be Guangdong Province, Fujian Province, the special administrative regions of Hong Kong and Macau. Before I even get into the areas here over here in China, I want to commend Vanderbilt for all the intellectual property items that are on your website. I'm actually on it right now. I know that of course, the school mascot is the Commodores. And the only reason why I raise that is because we've had trademark squatting issues here in China where opportunistic, not so nice people have tried to register lots of different universities' names, whether it's the Duke Blue Devils or USC Trojans, whatever. And it's nice to see that Vanderbilt University has such a robust intellectual property program, particularly in its law school. I see that there's a Vanderbilt Intellectual Property Program for students. There's an Intellectual Property Association at the law school. Also, I noticed that the Office of General Counsel has 3 full-time attorneys that deal with intellectual property. As many of you know, universities are a real repository of innovation, but also a lot of intellectual property, whether it's trademarks, patents, possibly trade secrets. Of course, because you're all located in Tennessee, copyrights, I'm sure, is a big thing with regard to the music industry. But because we have such a diverse group of folks that are on the call today, I just thought I'd mention some of the bigger issues that are here in China that might be of more interest to you. Certainly for our folks that are inventors, folks that are small and medium-sized enterprises, the e-commerce issues are probably the most prevalent and the most relevant to you all. This is the home, of course, of a lot of manufacturing. There's a lot of sourcing of products and materials from China that are then sold on eBay or Etsy or Amazon. Also, the enforcement issues sometimes can be tough, particularly for the smaller and medium-sized enterprises. So those tend to be, I think, something that the smaller folks, we understand sometimes they don't have the enforcement budget or the budget to pursue things, 10,000 miles away from, say, Tennessee all the way over here. So it's important to, of course, think about registering the intellectual property, work with your intellectual property counsel or even just your general counsel to sort of take stock of the most, frankly, I consider to be the most important asset that you have, which is your intellectual property. The fact that sometimes when small and medium-sized enterprises can't leverage themselves because of the small size, we are now beginning to work with large e-commerce platforms such as Amazon, which has just recently established a counterfeit crimes unit in which they, as you know, lots of people go to Amazon to buy practically everything. And sometimes there are going to be, Amazon fulfillment centers, their own warehouses, but then it's also going to be a third-party seller that sells on Amazon. Sometimes we don't know the provenance of the goods, whether or not they're genuine or not. And when some things go wrong with the purchase, and or let's just say an inventor finds that some of the stuff has been misappropriated by somebody else, whether it's their images or a product, they've reversed engineered it and now they're selling it under a different name through the Amazon trade channels. Amazon is now starting to stand up a program in which they're assisting small and medium-sized enterprises. We have that sort of conundrum over here with the e-commerce platforms such as Alibaba and Taobao. Also, new creations such as WeChat, which does not bill itself as an e-commerce platform, but is more of what they call a social messaging platform, so people can talk about this, that, and the other. It's very convenient. I use it over here. It's also a very big payment platform for contactless payment. It's almost like its own ecosystem, but it's a very unique invention here in China, which is starting to spread around the world in that there are WeChat circles, if you will, circles of friends. And sometimes within those small little private chat rooms are where counterfeit transactions are occurring. This is a major problem for our rights holders trying to penetrate those chat circles. We need to have probable cause to in order to pierce the veil of secrecy over here, sort of like a showing of probable cause, and that becomes very, very problematic. So that's an issue that we're working on. Just want to also point out, too, that we have, in addition to the Patent and Trademark Office, we're also working, of course, with our State Department, also with U.S. law enforcement. We have folks over here who are with the Department of Homeland Security, Immigration and Customs Enforcement, Homeland Security investigations. They're charged with stopping and interdicting counterfeit products. So we have a lot of different avenues to explore. Those are just a couple of the issues. I know that folks might have more specific questions about patents or trademarks or copyrights or trade secrets, but just wanted to give you a little bit of the flavor of what I think a general audience, especially ones that are starting to do business out here in Asia, are interested in. And so with that, let me turn this over to Luciano Marchione, my colleague who's over in Brussels, Belgium. So thank you.
So hello, my name is Luciano Marchione. Actually, I work here at USPTO based in Brussels. We are part of the delegation to the U.S. mission to the EU. And we're not only working here in Brussels, but we're covering the whole territory of the European Union. So we have 27 countries. We also work in the UK and also in the EFTA countries like Norway, Switzerland, and Iceland. So we cover a very big area, and we are doing all the services, or providing all the services that Dominic mentioned. And we are a lot in contact with small and medium corporations, or companies. So we hear a lot from them, which are the issues that they have in Belgium and in Europe in general. So I would like to point out which are the biggest problems that normally we find, and also explain also some of the characteristics of Europe in IP. So what we find first is that there are a lot of cases where the corporations or the companies think that they just register the patent in the US, and that is enough.
Luciano, excuse me, sir, we are really having trouble hearing you. Maybe it's just me, but can you get a little closer to your mic, maybe?
Do you hear me better?
Much better, thank you.
Okay, perfect. So I will shut off the video. I was saying that here it's common to see that SMEs in particular, they think that they have registered or they have obtained patents in the US, and that with that it's enough to be protected all around the world. And I think that here, because Europe is a developed area, that they can enforce their rights here in Europe too. But no, that is false. You also need to obtain patents in Europe and in the different member states. So that is problem number one that we spot. Problem number two is also related with registration of trademarks. Also, many companies do the due registration process in the US, and they think that with that is enough, and then they find out that somebody else in Europe likes their trademark and register it here, and then they have to start a whole process in Europe to try to cancel or annul the trademark. So that is also very important. And finally, in a very similar vein to what Corra was saying, there are a lot of conflicts with online markets, and I think that this is something that should be stressed. Like Europe and also the US are the principal victims of counterfeiting. So there is a constant influx of counterfeited products to the EU, and this is a phenomenon that keeps growing. And even though there are efforts to fight this is something that doesn't stop, and on the contrary, it's getting in some cases worse. So we're finding many cases where small companies from the US have conflicts with online markets here in Europe. So, having said that, I will mention which are the biggest characteristics of the European Union in relation to IP. First of all, here, and the difference to the US, there is not one patent for all the different states or all different territories. You have to obtain a patent for each member state. And this is something that can be quite burdensome, but luckily there is a mechanism in something called the European Patent Office, where you can try to obtain not a single patent, but at least what is called a bundle of different national patents. So this is a procedure that speeds up things and makes the patenting process a bit cheaper. So many times we are asked by the companies what they should do, if they should obtain a patent only in Germany or in France or in some other country, and or if they should go to this system of European Patent Office. So more or less the rule of thumb is that if you want to obtain a patent in 3-4 territories in the European Union and also some other members that they have that are outside of Europe in this European patent system, probably you should obtain a patent or this bundle of patents through the EPO, the European Patent Office. Something that happens quite often is that companies apply the logic that they use in the US to the European Union, and this can bring a lot of problems. And why do I mention this? Because in the US there is a grace period in which you can delay a bit the process to obtain the patent. While here this doesn't happen, and maybe somebody publishes their invention in the US before starting a patent procedure, and then they try to obtain a patent in Europe, and this can cause that your patent application is rejected. So please be very careful with that, because it's a big source of headaches for companies. And also we receive many questions about Brexit and patents, and in principle this doesn't affect the patent system, because you can still file a patent directly in the UK or through the European Patent Office, because the UK is still part of that system. So that didn't change at all. And lastly, there are some patent titles in Europe that in some, for example, in the US don't exist, that you have utility models. So basically what you try to obtain is a title that's similar to a patent, but doesn't go through a registration process where it's an analysis and an exhaustive procedure in which the different characteristics of the patents are looked. So this is something that is very common to use in Germany, because it's cheaper and faster than obtaining a full patent. But in this case, it's recommended that you obtain legal advice and to decide which title is better for each circumstance. In relation to trademarks, this is something that also has different systems in the European Union. You can register trademarks locally in each of the individual member states, or you can also go to the EUIPO, the European Union Intellectual Property Office, and try to obtain an European trademark. So if you obtain the European trademark, you're already protected with this trademark in the 27 member states of the European Union. And in this case, yes, Brexit affected, because no longer this title covers the UK. So in this case, you should try to obtain a trademark also in the UK in a separate way. And going back to the issue of online markets, it's very important that you register the trademarks in Europe, because in many cases, when you try to take down an illegal product, like a counterfeit, or a product that has other characteristics and that make it illegal, many cases the online markets, the intermediaries, the platforms will ask you to prove that you have the title in Europe. So we see this with many companies of the US, that they have obtained a trademark and they're selling the product for many years, and then somebody's copying it and selling it in Europe. So this online market, like Amazon, and others, will ask you, okay, hey, where is your trademark register? And if it's only in the US, sometimes they will not really help you to take the content down. So beware with that. I try to obtain the trademark in Europe too, and also in China, because many of the products come from China. In relation to copyright, here there's not a registration system like in the US. So in many cases, if you want to save a proof, then you know that I created a single kind of work, like, for example, a book. You can register in the US, and eventually that could be used as proof in Europe. But in principle, here you will not be able to register. And this is something that we are being asked a lot of times. So for copyright, just go to the US Copyright Office. And finally, I would like to briefly mention that apart from the systems that exist today, that the European Union has tried to improve a lot the patent system, and in the future there will be probably a unified patent title, and this title will allow you to obtain a single patent for 24 or 25 member states. This is being debated depending on which countries will ratify this agreement, but the Europeans are hoping that this system will start functioning in 2022 or 2023. So this will be extremely important, especially for SMEs, because you will not have to deal with going to Germany, to France, going to the European Patent Office and then having to validate the title in different member states. So in this case, you go to the European Patent Office, you obtain one patent. And this patent is already valid for the whole European Union, or at least all these countries that ratified the agreement. Spain and Croatia and Poland are still not part of that, but at least the biggest markets, are there. But remember, because of Brexit, the UK is not there, so you will still have to obtain an individual patent for the UK. So these were the topics I want to speak to you about, and if you have any question, I will be here, or if not, after this conference, you can contact us. Thank you so much.
Thanks, Luciano. Let's move on to David.
Hi, everyone. It's great to be with you today. Thank you for taking the time to meet with us. I cover Brazil as well as the other countries in Mercosur, which includes Argentina, Paraguay, Uruguay, and Venezuela, and also French Guiana, Guyana, and Suriname. So basically the eastern half of South America. And despite having all those countries in my portfolio, Brazil takes up most of our time, and that's where I'll focus my remarks today. I wanted to maybe touch on a few things that might be of interest and or helpful for inventors, startups, entrepreneurs who are kind of at the beginning of the patent process. And of course, there's far too much material to cover in one brief sitting here, but I'll touch on some highlights. So first, let me say a few words about a backlog. Obviously, if you're at the beginning of the process of protecting your intellectual property, you probably are hoping to get that protection as quickly as possible, maybe so you can get some funding from investors, and just maybe to help you market your product, right? And so in terms of seeking trademark and patent protection in Brazil, Brazil's trademark application pendency reached a nadir in 2019. That's the year that Brazil joined the Madrid Protocol, and they had put lots of effort into working through their backlog of trademark applications. And so the pendency was brought down to a period of several months. It's been creeping up since then, unfortunately. It's still within the guidelines of the Madrid Protocol, but it will take a few months longer than previously to obtain trademark protection in Brazil. The patent backlog is a much bigger problem. For many years, the patent backlog was over 10 years, and this meant that a patent is good for 20 years from the filing date. And so if you were waiting for that patent to be issued for 10 years after filing or more, then you were left with very little enforceable patent term. And 2 years ago, also in 2019, actually, the Brazilian Patent and Trademark Office implemented a plan to combat the backlog. This plan was intended to reduce the backlog by 80% within 2 years. And the timeline slipped a little bit. They extended the program by 6 months till the end of this year and hope to be able to reach that 80% mark by the end of this year. What that means in practical terms is that the average wait time to get a patent issued in Brazil has dropped from over 10 years to somewhere between 7 and 8 years. So this is an improvement, but still, arguably an unreasonably long time to get patent protection here in Brazil. Now, for those of you who are still in law school, here's an interesting thing to think about. The Brazilian IP Association filed suit against the Patent Office and the federal government here, claiming that the Patent Office needed to be given more resources or else it could not reasonably fulfill its constitutional mandate to issue intellectual property protection. So there's certainly some interesting questions of constitutional and perhaps administrative law in there, but we will see within the next couple of years probably what happens with this lawsuit. In the meantime, we strongly encourage US stakeholders to look at the fast track examination options that are available to them in the Brazilian Patent Office. And in fact, there are a number of these programs, 17 to be exact, and these programs have an average tendency of 1 year. So you can compare that to the 7+ years that it will take to get a patent issued without using one of these fast track programs. And you can really deliver good results to your clients or obtain good results for yourself, for your startup, for your company by using one of these programs. The programs are available on a number of bases. One is for green technology, another is for technology that's already being offered in the Brazilian market. There are categories for advanced age, ill health, and a number of other things. Maybe one last one that I'll mention is the patent prosecution highway. This is an agreement between the US and Brazil that allows the work product from the United States Patent and Trademark Office, the search results, et cetera, to be used by the Brazilian Patent and Trademark Office when they examine a patent application that has been filed in both places. And a favorable outcome in the US can then be used to expedite a favorable outcome in Brazil. So we encourage you to look at these programs. Of course, we always recommend that you get local counsel here in Brazil or in whatever country you're seeking protection in, who can guide you through the particular details of using any one program. Finally, let me close by just mentioning that if you seek trademark protection in Brazil using the Madrid Protocol, and for those who may not be aware, the Madrid Protocol is a system of international registration for trademark applications. You don't actually get one international trademark, but you can file a trademark application using the Madrid Protocol and then use that application to enter different countries and have your trademark examined in all of the different countries that you're interested in which you're interested in having protection. And if you do that in Brazil, you just need to be aware that the Brazilian Trademark Office does not always notify WIPO, so that WIPO can notify you that an office action has been issued in Brazil. And this is not what is supposed to happen under the Madrid Protocol, but it is what is actually happening on the ground. And so the way to deal with that issue is to line up local counsel as you file your trademark application in Brazil through the Madrid Protocol, and then that local counsel can monitor the official gazette here and let you know once an office action issues. Happy to answer questions about any of this or talk about other subjects, but thanks again for the invite to be here and speak with you, and I'll pass it on. I think John was next, if I recall correctly.
Thanks, David, and hi, everyone. So I'm John Kabeka. I'm the IP counselor based here in New Delhi, India. I serve not just India, but the other 7 countries around India as well, including Afghanistan, Pakistan, Bangladesh, Nepal, Bhutan, Sri Lanka, and the Maldives. And similar to David, most of my focus is on India, the largest country in my region. So I will focus on that today, but I did want to share just holistically throughout the region, enforcement of intellectual property remains a challenge, and it remains a challenge for a variety of different reasons. The smaller countries are still very nascent in their development of an IP system, let alone an effective enforcement strategy. And large countries like India, because of its size, have several complicated mechanisms that involve the enforcement of intellectual property that can be cumbersome and fraught with pitfalls. So if you find yourself in an enforcement situation here in South Asia, please do reach out and be happy to assist you. Throughout my work here, we do a lot of work on some very weedy intellectual property legal matters, which I won't go into today, but just rest assured it does cover every aspect of intellectual property. But one that I think is really important to this group is trade secrets. And that's because as early stage entrepreneurs and startups, typically your first form of intellectual property is going to be trade secret protection. You're in stealth mode, innovating, developing. Hopefully you know that you shouldn't be publicly sharing the aspects of the technologies and the innovations that you're working on because of the disclosure risks involved with that. But in India, there is no trade secret protection, and this is a tremendous problem for a variety of reasons. One is because in the U.S. there are often many relationships with Indian entrepreneurs and startups in their own right, and software programmers and other engineers that work together with U.S. enterprises in the development of innovation. So absent effective trade secret protection here, U.S. industries run the risk of losing their hold on their trade secret. So as a result, in India, in absence of an overarching trade secret law, we use contract law. But again, as I mentioned, with the enforcement of intellectual property, including enforcement of contracts, being quite a complicated landscape, it is really important to make sure that you're capturing and protecting yourselves if you are involved in any sort of partnership with an Indian enterprise or an Indian entrepreneur. So this is one thing that we work really closely with the central government here in India, but also across the various states in the region. We have a program that we engage across different states as the states throughout India seek to draw more foreign direct investment into their state. And two ways that I've been working with them to do that is by making them aware of how attractive a stronger trade secret protection within the state, could draw more investment, but also mechanisms to commercialize technology being developed within the state and how to commercialize technology within institutions, out of institutions into the marketplace. So these are some things that we work on. We partner really closely with the National Research Development Corporation, which is a central body here in India that very much focuses on finding ways to streamline the innovation life cycle, to work with academic institutions, to work with policymakers to make things more effective. So we have a lot of work in progress that we're hoping to see some fruition on in the coming months and possibly years ahead. One of the things that in my work from California, working with the USPTO to now coming to South Asia, is things just take a lot longer here to get done. But at the same time, I'm still very optimistic that we can help create a system going forward. Lastly, I did want to share, as going back to startups, is India does offer a variety of incentives for startups, for academic institutions, and also through their IP office, and also with the support of the Ministry for Micro, Small, and Medium-Sized Enterprises that create a lot of different incentive programs. And they've been working very closely together and have done quite a bit of work during the pandemic to keep the innovation engine turning here in India. That said, patent filings are still relatively low if you look on per capita, but at the same time, they are increasing, which is a very healthy sign. And so as patent filings increase, we hope to see the enforcement of those patent rights, especially as more Indian enterprises seek patent protection. And it's not just multinational corporations or US filers protecting their rights in India. we're seeing more and more of those filings come from India, and that's making it more important for India to create an effective enforcement regime. The last thing I'll mention is with respect to the Ministry of Education. We've been doing a lot of work with them in trying to heighten the awareness and education for entrepreneurs and for students, both in research institutions, in academia, but also in secondary schools, to help raise the bar on the respect for intellectual property, the need to respect intellectual property, have a basic understanding of intellectual property as India seeks to evolve its culture to embrace its innovative capacity. So a lot of more work to be done there. One thing that we're working on is working with a startup here that has roots in the US and here in India that will take our educational programs and translate them into the 10 major languages automatically through their the tool that they're developing. So I think breaking down the language barriers is going to be a tremendous asset, not just to my region, but I think globally, and looking forward to see how that evolves in the months and years ahead as well. I'll stop there, but I'm happy to answer any questions that you may have.
Thanks, John. I think
I'll
we
turn
can
it over
move on.
to
Yeah, sure. To Pete.
Pete.
Yes.
Thanks, John. Thanks, Dom. So, hey, I'm Pete Meriveri. I'm the IP Attaché for the Middle East, North Africa. I'm going to tell some stories just kind of about the sort of innovation environments and entrepreneurship out here. So I've been in the region for 4 years now. And when I first arrived in 2018, the Middle East and North Africa sort of had just sort of realized that they had to make a change in their economies to kind of get off of oil and to really create a knowledge-based economy. And they knew that IP was important, but didn't really know how it was important. Another big issue that we saw was unemployment, and unemployment not just for jobs, but also for national security. And remember, during the Arab Spring in 2011, a lot of the issues that raged sort of afterwards was mass unemployment of youth, who then joined ISIS in Syria. And so countries in the region saw entrepreneurship and startups as not just an economic issue, but a national security issue. And so when I came out to the region, countries along my area were trying to create startups, as many startups as possible. And so the first story I'm going to share is about Tunisia, knowing that has that history of wanting to make sure that their youth was employed. So in 2018, Tunisia passed the Startup Act, which was a national initiative to sort of force as many of its college students as possible to be entrepreneurs, where they would give students about 9 months off to create a business. And when I arrived in the region, I had the opportunity to go there my first summer, spend a week there and meet people. They wanted me to talk about intellectual property. Because as Dom mentioned, one of our jobs is to increase the ability for these countries to protect IP. And if I go to, for example, Tunisia, and I say, hey, this big US company is losing a lot of money because you're not protecting their patents, well, Tunisia's going to say, well, okay, fine. But if I go to Tunisia and say, look, all your startups are not getting patent rights because of these issues, that's a bigger sort of motivation for Tunisia to change its IP laws for the better. So when I arrived in Tunisia, we go to their first sort of tech transfer office in Tunis, and they come to me and say, hey, Pete, we have 3 patents. You, as the US government for IP, can you go and find people to license these patents? And I'm like, that's not quite how patents work. You need to have a market. Who did you make the patents for? So I was like, okay, this is an interesting place. Again, my first time in Tunis. And then at around 12 that day, we met with the Ministry of Education, and they were briefing me about all of these amazing things they're doing for startups. So they were saying, hey, Pete, we're doing these pitch competitions all over the country. I'm like, wow, that's great. They're like, yeah, we're teaching like thousands of people every week how to talk and disclose their inventions to everybody. I'm like, that doesn't sound good. They're like, oh yeah, we're just having them tell everybody everything. And again, I'm a patent person. I was an engineer, patent attorney. That was my roots. And so I'm just in this meeting with the Ministry of Education, with our head of mission there, and my face is just cringing because as a patent person, do not disclose. And having the Minister of Education brag about how he was making all of the startups disclose, I was like, this is not good. Exactly. Just it was hard. I hurt inside for a few days afterwards. So after that, I was like, okay, this is gonna be a tough trip to recover from. Well, the afternoon got worse. So the afternoon, sort of as Dom mentioned, we like to go and do sort of outreach to entrepreneurs and startups. So we found a good incubator in Tunis, and we set up a workshop for their startups, talk about IP. I've done this many times. I was like, okay, it'll be fun. New group, new students. So we get to the incubator, and there's about 30 different startups in the incubator. And the head of the incubator says, hey, Pete, we got these 7 that we want you to talk about IP with. I'm like, okay, well, what about the other 23 in this? And he's like, they have no IP. I'm like, well, this one over here has a brand. This one over here has a design. They're like, no. We only focus on patents. And again, I love patents. I'm a patent person. Well, it'd been a tough day. So I was like, you know what? You want me to come talk about IP to your people? You need to invite every single person to come, because every single company, every single business has IP. And as John said, one of the most important ones, trade secrets. When you look at a lot of the economic data, most of the IP intensive industries that create jobs, trademark rights, brand development. And so I didn't throw a fit being a diplomat, but politely encouraged them to invite everybody, which we did, and a great discussion about IP. So that was my first 6 months on the job in the region. I share these stories because this is something that we've been trying to change in the region. And we see it, I think, initially in the US for a bit, but in Middle East, North Africa, the impression of how IP works for entrepreneurs and startups. And so it's really been an incredible last 3.5 years since that trip, going back to Tunisia, working with their ministries to change these policies, where now they put in place disclosure type of briefings for the people at these sort of events where they train startups. Now we're working with the tech transfer offices to develop actually strategies to develop commercially based innovations before spending thousands, tens of thousands of dollars on patents that'll never be used. So in my region, it's just been an incredible sort of growth of startups. And then I mention this because for US companies, even for startups, we're seeing massive amounts of potential for bringing intellectual property to the region, especially in the Gulf region. We're seeing countries such as UAE, Saudi Arabia, Qatar, actively chasing policies to capture IP. And we've seen issues, we've seen sort of examples of US companies that have a patent portfolio coming to the Gulf, being able to market the patents themselves, not actually the manufacturing, not actually the development, and having Emirati investors, having Saudi investors take those ideas and capitalize on them. So it's a really exciting time out here. And if you like being a startup, like doing this type of things for IP, this is a great place for it. I will mention one other challenge that we are facing, which if you are interested in becoming an IP professional, this is a great area. So think about a landscape where everyone wants to build a house, but no one is a property surveyor. No one knows how to get a loan. No one knows how to sell property. That's sort of the issue we're facing right now in the Middle East, where we have every single person wants to be a startup. Every single person wants to be an entrepreneur. Everyone is trying to create IP, but there's not enough IP professionals to do the right capture, right analysis, counseling for all these startups. Again, think about thousands of startups being trained every single week in Tunisia. There's probably about 20 skilled IP people in the whole country. It's not enough. So if you're looking for career tracks in IP, the Middle East, North Africa is a great place to come out. It's also a very warm place. People were joking today about how cold it was. This morning, it was quite cold. When I was walking my dogs this morning, it was a brisk 75 degrees. So if you don't like cold weather, this is a great place to come out and work. And for startups and innovation and entrepreneurship, I mean, I really can't say more about right now. It's a great time to come out. So that's sort of it for me for now. But Dom, back to you.
Oh, thanks, Pete. I think we'll go back to Yessi for questions.
Yeah, so some are starting to come up into the box, but I wanted to start with some just a little bit, sort of redirect a little more general questions. One of them being, we've learned about these markets. I take notes, so I was listening. I was just taking copious notes. One of the things that I know jumps to mind first is we hear you, this is exciting. How do we get in touch with you? So I'm a startup, right? Let's walk it backwards. I'm a startup. I'm interested in that in one particular market or the other. How do I work with an IP attaché? How do I connect? Are there fees to me as a US startup? How does that process work to just even tap into your expertise?
Maybe I can start off with that, and then others can jump in. But so there are no fees, and the contact information for each of the attachés is on the USPTO website at uspto.gov. And we have not only the 5 attachés who are here today, but we have a total of 13 around the world. So covering most of the markets that people care about in terms of investment opportunities around the world. So what normally works well is to go to the USPTO website, find their contact information, shoot them an email and say, Pete, I'm thinking about going to Tunisia and investing there. I'd like to introduce an invention there. Maybe start a spin-off business or enter a licensing deal. And then, can we talk by phone? Maybe Pete would exchange some additional thoughts by email, and then ultimately you might want to have a phone conversation, schedule a phone conversation with them. The phone numbers are on the website, but it's just because of the different time zones, it's a little bit more difficult to just do a cold call, to a completely different time zone. I mean, right now for Conrad, it's 12:30 in the morning. So, it's sometimes hard to catch these guys. I don't know if anybody else has any comments on that one.
And I'm
just
awake.
very quickly.
Just want you guys to know that.
Conrad is awake.
He's still awake.
No, I mean, I'll just add. I mean, for example, I had a U.S. company reach out to me 2 days ago. They wanted to file patents in UAE, and we have a virtual meeting with them tomorrow morning. So it's as easy as emailing us, setting up a virtual meeting. And now that we're pretty comfortable with virtual meetings on the fly, I think it makes it easy. But I mean, it's a free consultation. I mean, everything we do is free and fun.
Fantastic. John, did you have a question? I'm not sure. Okay, I'm sorry. And John Quebeca, I saw you were about to say something. Sorry.
Okay. Yeah, I was just going to add that all of us and most of the attachés are also part of the Foreign Commercial Service, so we can also connect you with our experts in the respective industry portfolios that where they actually can assist with doing background checks on companies you might want to do business with or a manufacturer. So there is a whole nother part of the federal government that we can connect you to help as well as it intersects with intellectual property.
Yeah, fantastic. I do know that there are startups. I know one in particular that's a couple of doors down, where there is this idea of working with partners and even employing skilled either technical laborers, meaning developers and people with sort of that sort of techno ability, and sometimes with artistic labor in terms of people that can design in other countries. And so this idea of then, I think it was something, I can't remember exactly who said it, but this idea of being able to safely talk about, I think it was you, John, about working with employees and not necessarily companies, but individual employees in other countries, but feeling safe in doing so, and creating these multinational layers of talent, which is great. But your point about protecting the trade secret or protecting the IP of the company is very interesting. And to that point, to segue, Dave Owens had a question about, is India the only country without trade secret protection?
So no, unfortunately, but and India is a fully functioning member of TRIPS, the trade-related aspects of intellectual property, and so in TRIPS there are provisions for protecting confidential business information, but the way India goes about it is a little disparate, and to say the least, and primarily through its contract law. So it doesn't have, like in the US, a single trade secret law. It's covered arguably over several different laws and legal mechanisms, which makes it more difficult. But other countries, that are still developing or at least developed country status, have different you know, their laws are at different levels. And so there's quite a few countries that don't have trade secret protections, but look towards developing them as well.
Right.
And,
another
I want to
question.
just add that very, just add that very quickly. I mean, just because they have the laws doesn't mean that they enforce them. I mean, for example, in the UAE, I mean, we just got new trade secret laws about 6 months ago, but I would not recommend people think that that's going to be enforceable. And not just because it's new, but because judges out here have to provide a remedy. And if that remedy is not going to be sort of conducive to the loss of that revenue, it doesn't matter. And it'd also be just also think about who that government works with, like for example, UAE, closely with the Russians and Chinese. And so that type of trade secret can also be shared within those unfortunate channels.
That makes sense. I know sometimes people get focused on, you know, the technical patent and technical IP, but I know that some of you have mentioned it more than once, which is trademark matters too, and branding matters too, in terms of, you know, and I know everyone should be familiar with some of the biggest fiascos in branding and in copywriting and trademarking with not understanding the local language. What's your best advice to U.S. centered startups in terms of entering markets and the language issue, and how do they get help with that?
Conrad, you've
I'll
probably
jump
had
in
some
here.
experience with that. Yeah.
Right. I was just going to say, one of the things that you really want to do is work. If you have an attorney in the United States, that's great. I think I would suggest that the person work with an attorney in that particular country, whether it's in the EU or in the Middle East or in India or here in China, because every country is different. And of course, language is different too. And just like with English, the way, let's just say you wanted to take an English mark and then you wanted to, let's just say, transliterate it, you know, sort of make it into a phonetically equivalent type of mark here in China, all right? So that, you know, and Coca-Cola and Pepsi-Cola are perfect examples. They do have them phonetically translated. They're not exact representations, but they're close enough. But you want to have someone who looks at those, the Chinese characters or Arabic characters or whatever, and make sure that you're not, all kidding aside, you know, using characters that, you know, might say, you know, delicious toilet brush or something, okay? It may sound like what the mark is supposed to be, but then people look at this and they go, ugh, I don't want to buy that. And then you don't realize it. And so you really do need to be very, very careful, just like we're careful the way we develop branding in the United States. It's the same way in another country. And the only way you can kind of get that expertise is by working with folks over here. Beware of that. And then, of course, because China, like a lot of the jurisdictions that are on the call tonight, may have first-to-file protocols, whereas in the United States we use first-to-use that are established by dates of use in the United States. First-to-file, you may find somebody grabbing the mark before you can get it registered. Or you may have, let's just say, a foodstuff, but someone registers the exact same mark in what in China here, what we call subclasses. So it may be unrelated. Maybe you have a foodstuff and somebody else has the same mark for alarm clocks, but they can possibly use that mark to block your registration or to hold it hostage. Essentially, they're squatting on the mark, using the mark, the exact same mark for different goods, but saying, well, you know, I'm here first, I have the registration, so pay me some sort of usurious licensing fee or fee to buy the mark. You know, navigating over here in China is very, very difficult. I wouldn't want someone to try to come over here and do it themselves. I hope that helps with at least some initial pointers. And you know, although we cannot ourselves, the Patent and Trademark Office, recommend attorneys due to you know, potential conflicts of interest, we certainly can point you to, and I think this is sort of the same thing in other countries, American Chambers of Commerce in the respective jurisdictions, whether it's EU or South America or whatever, and they have the ability to recommend IP attorneys that can help rights holders. Thanks.
And
Fantastic.
can I
Thank
add
you.
real quick to that is that the one thing that that you need to be wary of is relying too much on things like Google Translate to translate something, because I used to do a lot of work with China, and it may be great for an initial translation, but always, always, double check with folks local on the ground, because the last thing you want to do is translate something and offend someone on the other side, in which I know that Google Translate has done that before, and it's been pointed out to me to not do that. So that's one thing. I think it's great for an initial cut, but definitely not for product launch. Let's put it that way.
Absolutely. Thank you. And I think that even applies within what's considered a similar language. You think of Latin America, the Spanish speaking countries, the dialects are very different. And you can actually say something in Spanish that in another Spanish speaking country is either not relatable or very offensive. So that applies there too. Well, I want to be mindful of your time. It's 10:38. Any closing remarks, Dominic or Hope?
Well, I would just like to thank you, Yessi, and also to thank all of your colleagues at the Wond'ry for making this event possible. It's been a pleasure for us to speak with you all today, and we really enjoyed your questions.
Wonderful. Hope?
And I just wanted to echo what Dominic said. Thank you so much for opening up the channels for us to connect with you. If you need a local contact in the same time zone, feel free to reach out to us. We are happy to connect any one of your entrepreneurs with any of the folks who are on the phone. We are the conduit for y'all in this area, and we look forward to connecting with you as things start to open up. And as we are doing one-on-ones and various things, we are always available to you as well as your entrepreneurs that are in your group. So thank you very much.
Yes, no, and absolutely. The answer to that original, if you would like to connect, the answer is yes. So anyone in our time zone, please go ahead and send that way. Thank you so much for all of your time. Thank you for letting us record you. We do have classes that are actually going on right now. So some of our students are going to watch you on the recording. We look forward to establishing better relationships and better collaboration. And all of you, thank you for extending yourselves. We will be in touch. Have a great afternoon.
Thank you too.
Thank you.